Welcome back. I'm Ladan Korhani. I'm a family lawyer. So today we're going to talk about how to respond to an application. So the forms that are required, it's the form number 10, form 35.1, and maybe a financial statement, form 13 or 13.1. We're going to discuss that a little bit later on which one may be required. So you receive the application and you see that there's your first appearance court hearing on there. Very important that you attend that. Okay, it's mandatory for you to attend. Now, you have 30 days from the day that you were served to serve and file your answer. So the Form 10, you fill out the first page. The applicant is the person that served you. You are the respondent. And if you go on page number 2, it's asking you some question there, whether or not you are agreeing with the applicant's claim, whether you want to make your own claim, and if the family history is correct. And on paragraph number 6, it's the important facts that form the legal basis of your position. Now, I usually like to combine this paragraph 6 with page number 5, where it says important facts supporting my claim. So what I do is I fill out the important facts supporting my claim on page 5, and I just put on paragraph 6, page 2, C, important facts supporting my claims. It's just because what you're explaining, could be similar, so it's just easier to just have everything in one area. So when you go to page number 3, it's asking you to answer to sign. You can sign this and you can date it. And page number 4 are the claims. I asked the court for the following claims. Claims meaning what are the orders you're looking for. So now you know what the applicant's position is. The court wants to know what's your position. Okay, so is there decision making that's an issue, as in custody? Parenting, are there parenting issues? Are there spousal support issues, child support, property? So you fill that out, you check mark what's here. If you were married, you check mark where it says under Divorce Act. If not, you check mark under Family Law Act and Children's Law Reform Act. If there are any property issues, you go where it says claims relating to property. Okay? So you do that, and as I said, page 5, important facts. You want to explain a little bit about the background, and you want to really respond to what the applicant has said in her area where it says important, or his where it says important facts supporting. There may be some allegations that are not true, that you don't agree with. You're going to want to put that here, and you want to have your side of the story. If you don't have enough space, just put C Schedule A and then put it under Schedule A. Or rather, maybe even Schedule B, because Schedule A would be where it says give details of the orders that you want the court to make. Now, I understand you've made the claims, you want parenting time, you want support or property issues, whatever they may be. But the details would be what kind of parenting time? Are you looking for week about, as in 1 week you, 1 week them, or are you looking for primary care? Are you looking for specific alternating weekends? You want to put that here. So the court wants to know what is it exactly that you're looking for. And then we have, so next page. Okay, so this is a direct response to the claims made by the applicant. So you see on the application where it says claims made by applicant. So here are 2 columns. One says, I agree with the applicant with respect to, let's say, support or decision making. If you don't, then you go to the second column where it says, I do not agree, and then you check mark which ones you are specifically not agreeing with. Okay? It also the last page is just about the family history. You see that also in the application. You fill that out, and that is done. Form 10 answer. It's a direct response to the application. However, if there are children involved and you are making a claim for decision making and parenting time, you have to fill out the form 35.1 affidavit. Okay. It's very self-explanatory. It just asks you a whole bunch of questions. You answer it. It asks you, for instance, whether or not you have a criminal record or any charges, pending charges. If you've been involved in any other kind of court hearings involving kids, whether or not the children or your child has any kind of disability, things like that. Okay. So you fill that out. The last page is to do with the plan of care, meaning if you have your child in your custody, are they going to have, where are they going to go to school, who are they going to have contact with, things like that. Now this is a sworn document, which means you cannot sign this unless you are in front of a commissioner of oath. So whether it's a lawyer, a paralegal, but if you go to the courthouse, they can commission it for you. So you can sign in front of a court. Okay? If there's been involvement, if CAS has been involved, there's some kind of involvement that had occurred with the Children's Aid Society, you need to fill out the form 35.1A. And again, it asks you questions. It's about a page and a bit. And this also is a sworn document. You cannot sign it unless you're in front of a commissioner of oath. Now, financial statement. If you are the payer, meaning you don't have primary care, or it is a shared parenting arrangement, or you're paying spousal support or maybe subject to paying spousal support, or Section 7 expenses, and Section 7 expenses are expenses relating to the children's daycare, medical, extracurricular activities. Those are usually shared, and it's above the child support payments. You need to fill out a financial statement. If you do not, the court will not take anything from you. Okay, it's mandatory. So if there are no property issues, okay, you can just fill out the form 13. Form 13, you need to put in your income, your expenses, and these expenses are on a monthly basis. It breaks down to specifics such as rent, mortgage, clothing, etc. And you need to put in your assets and debts. Okay. And this one is also a sworn document. Make sure that you have your notices of assessment for the last 3 years. You can get that from CRA. If you don't have it, you need to attach it. Again, if you don't attach it, the court will not take your response. So this needs to be also sworn in front of it needs to be signed in front of Commissioner of Oath. If there are property issues, and I explained it in my first segment, you need to fill out the form 13.1. Again, you fill out your income, expenses, but details about your assets and debts. So for instance, on the date of separation, what were your assets with respect to your personal account, investments, bonds, savings, property, vehicles, even if you have cash in a safe, it's all, you have to disclose that. And your debts, line of credit, mortgage, credit card, student loan, etc. You also need to disclose what assets and debts you had on the date of marriage. You may not have that information if you've been married for too long and you don't have it, that's fine. But if you do, you need to disclose that. So again, this is also a sworn document. So you need to, once you fill out everything, you need to get a commission. So again, you can go to court and have a court clerk commission it. And once they have commissioned it, you can serve the applicant. You can serve the applicant. In some jurisdictions, they will allow service via email. In other jurisdictions, they may not. So you can either mail it or serve it personally, or if they have a lawyer, you can drop it off at the lawyer's office. Once you have served, you go to court and you fill out the form 6B, it's the affidavit of service. It's just a sworn document that states that you have served the applicant, the method of service, and date and time. And you sign it in front of the court clerk and you file it. So there's your response. So if you don't respond within the 30 days, you can ask the applicant for consent to late file. If the applicant does not give that to you, there are other methods. You can ask the court. You can complete what's called a 14B motion. It's another form that you can get online, and it can just say that you are in order that you want to file and serve by a certain day. With that, you have to also have a form, an affidavit. And again, you can get these documents from the Ontario Court forms.on.ca, explaining why you need that extension. So you need to have a good explanation. In any event, whether you've served or not, you need to attend your first appearance court, and usually in most jurisdictions it's virtual and it's before court. This is it. This if you do this, this means that you have responded, and the court hearings will proceed, and you will go to your first court hearing, and it goes from there. Thank you, and until next time.